Good morning, everybody.
Good morning, Doug.
Okay, we begin on 33B towards the bottom, but 6 lines, 5 lines from the bottom, 6 lines from the bottom, the two dots. Dine Mamanos, okay, that's the right place here. Dine Mamanos Hakol, the Mishnah had said um, that if you have people in the audience, like students in the audience observing the case, then they can um, with in monetary cases, anybody can insert an argument or advance an argument, an idea about the legal ramification or the legal details of the case. But with the nefashos, with capital cases, the audience can't bring up arguments for conviction, but only for acquittal. So hakol afilu edim. Now, when the Mishnah says everybody, does that include? That seems to include even witnesses, right? So you have a witness who's a prosecution witness, and the witness is listening to proceedings and says, "Well, what about this angle? Doesn't that indicate that he should be acquitted?" So, in other words, against his own testimony. Um, Name of Nisin Rabbi Yossi, Rabbi Yehuda, he v'lo Rabbana. Maybe this indicates our Mishnah is the view of Rabbi Yossi. The Tanya, we have a brisa. V'ena chod layana b'nefesh. A solitary witness cannot be heard about a capital case. Bein l'schus, bein l'chava. So that means you can't have a single witness, either for either side, prosecution or defense. Rabbi Yossi Bar Yehuda Omer, Ono l'schus ve'en ono l'chayav. You could have a single witness that for acquittal, but not for conviction. So, does that mean that our Mishnah accords with Rabbi Yossi Rabbi Yehuda? What does that have to do with a single witness? The Rama says that the pasuk is talking about testimony, but we already know that the testimony of a single witness is no good. So the Gemara is applying this statement to what we're discussing, which is, can a single witness advance an argument against his own testimony? So Amar Papa says, "B'yechad min talmidim." No, we're not, as I explained before, we're not talking about any single person like a single witness. No, we're specifically talking to the talmidim, the students sitting in the ranks. They can participate in the case, but if it's a capital case, only for the acquittal side. My time with Rabbi Yossi Bar Yehuda. Now, what is Rabbi Yossi's reasoning? Torah says a single witness cannot be a prosecution witness in a capital case. So the way it's phrased is like to convict the guy, to kill the defendant. That implies that he can speak for the defense. Okay, that seems reasonable. Rabbanan, why do the rabbis disagree that a single witness can't participate at all in the case? So because it seems it doesn't have a good look, right? Like he's he's arguing on behalf of his own testimony. So he appears to be kind of biased. So um, it it's um, he he's if he is talking against his own the results of his own the potential results of his own testimony, then that looks like he doesn't have much confidence in his testimony. In fact, it looks like he might be trying to cover up the fact that it's false testimony, and he doesn't want to be found out, and that's why he's desperately looking for arguments against his own testimony. So it doesn't look good. V'Rabbanan Hailamus Darshibe. Okay, so that's logic, but what are they going to do with this pasuk that Rabbi Yossi advanced? We're talking about one of the students, as we said, Tanya. Kedatanya, Amar Chamina Eidim Yishli al Eschus. If one of the witnesses says, "Oh, I have a legal argument for the defense," Minayin Shein Shomim Lo, we don't listen to him. Talmud Lomar, because the Torah says, "Eid Echad Liyad." A single witness can't speak out. Minayin Lecha Mina Talmidim She'amar Yeshli Lamilav Chova. If one of the students says, "I have an argument for the prosecution, minayin shein shomi lo, we don't listen to him. Talmud Lomar, echad liyana b'nefesh lemus. They're taking out the word aid, but the phrase a single person shouldn't liyana b'nefesh lemus shouldn't speak in order to convict in a capital case. Okay, din nefashos
He's not talking
hamalamed.
for
The
himself, is
Mishnah
he?
has. Sorry.
He's not really. He's giving testimony for somebody else, right? How does it matter what it looks for him? How he could benefit for him? He's not testifying about himself, is he?
No, but he's undermining his testimony.
What?
If you testify for the defense and then you start arguing for the prosecution, you're making it look like I don't really believe what I testified.
I thought we're talking about the case where a witness could testify to for for what's it to make him chayav, to make him
Liable.
liable, right? And I couldn't think of the English word, but
right. But if it's a defense, so it's a defense witness who we're saying can't come and say, "Oh, guess what? I have a legal argument that even though I testified for his defense, but really you should convict him."
Well, that doesn't make sense. He contradicting himself there. How can
right? So he's not exactly contradicting himself. Like, he is.
Well, he can't both
He's
sides.
standing by his testimony, but he's saying, but for this reason, like, maybe, it could be that he didn't get proper hasra, right? Like I say that I saw, I saw him commit the murder, but then he says, but you know what? You can't convict him because because of this legal technicality.
Well, okay, it's just that seems so odd. In today's court, the defense attorney wouldn't choose a witness that testifies against his own client, right?
Right. Well, in today's court we have a different model, right? In the courts we're talking about, there wasn't a prosecutor and a defendant. It was all the judges. And whoever says they have testimony, they have to hear the testimony. There's no prosecutorial discretion here for which witnesses to bring. That's a American and probably other countries' law model.
So these are just witnesses, but there's still a defendant versus a.
Yeah, it's the court that's accusing him, right? I guess you would say. But there's no office of the district attorney. There's no role for like that. It's all the judges.
So they're bringing witnesses to the event, but witnesses to the event. But who scours the witnesses? Who finds
the court,
witnesses?
The judges. The cross-examination, you mean?
Yeah, where do the witnesses come from? Who brings who vets the witnesses? Because the witnesses are
the judges. And that's what we're talking about. In a sense, that's what we're talking about. Like, what is the judge's responsibility in hearing out the witnesses? That's kind of incident. It's kind of adjacent to what we're talking about.
It's a different system.
Oh, for sure. Yeah. Okay. So.
Okay.
Yeah. Okay, din nefashos hamalamed. So we said that a judge, somebody who argued for conviction, can change his mind and say, you know what, now it occurs to me that maybe I was wrong, maybe I should be charged for acquittal. So you can go that way, but you can't go from arguing for acquittal to arguing for conviction. Loshanu Amaram Loshanu b'shatz matan matan. That only applies during the discussion. So in a capital case, if you start out arguing for arguing the side of the case that would acquit, you can't then say, oh, you know what, maybe I was wrong, and here's some argument that argues in favor of conviction. You can't do that. However, that's only during the deliberations. But b'shas Mardin, but when it comes time to vote, right, to thumbs up or thumbs down, Malamin chus or Malamin chova, then you can change your mind, right? Because otherwise the whole process is ridiculous, right? So we're not going to allow you to, once you've argued for the defense, we're not going to allow you to argue for the prosecution. And so okay, so I've been using the wrong words really, right? I've been casting it in a modern sense. So maybe that's what confused you, Ken. I've been using the words prosecution and defense. There isn't really that role, but there is that effect, right? So I really should say to convict or to acquit. Um,
Right, right.
However, when it comes time to vote, like if that's what you think, even if you've advanced an argument for acquittal, but now after the deliberations, you become convinced that you need to convict, then you have to vote that way. You have to vote to convict. Meisvei. So Gemara asked a question about that. Mishnah says Lamachras Mashkimin Ubain, that in a capital case you come the next day to do the Gemardin. Hamazaka Omer, somebody who argued for acquittal says Ani Hamazaka Mazaka Nivim Komi. I argued for acquittal, and I'm still, that's what I think we should acquit. Hamachayev Omer, and one wants to convict says Ani Hamachayev Umachayev Ani Bimkomi. I'm the one who I argued for conviction, and I maintain that. Okay, and this Mishnah says that if you argued for conviction, you can now argue for acquittal. But not the other way around. If you've argued for acquittal, you can't come back, change your mind, and argue for conviction.
That's a kasha.
V'halamachras, what we're talking about is Gemardinu. The context here is Gemardin, right? We're not talking about arguing anymore, but we're not talking about deliberations. We're talking about when it comes time to vote. And so the Mishnah seems to be saying that if you've argued for acquittal, you can't vote to convict. So Gemara says, well, wait a minute. If that's the case, lamachras masumata mileka. Like, why do you think that just because it's the next day, that you can't continue deliberations? Right? There's no indication that kikatayim shas masumatan. That this mission that we just brought is indeed talking about the continuing the deliberation. Okay, that's reasonable. Tashma, we have another proof. Danin elu keneged elu. You kind of you discuss between one side and the other, conviction and acquittal, until somebody gets convinced, right? In other words, if you have a deadlock, you have to win somebody over. If it's the case, if it's the case that you can change your view from acquittal to conviction. So why does the Mishnah only cast it one way? That until somebody who was convicting changes to acquittal, or it should say, or the other way around, right? So the Gemara says, Tanas chus kama hadar. No, that's the case. It really could be both ways, but the way the Mishnah wants to present it is in a favorable way. In other words, not favorable, but a way that would lead to an acquittal. But really, it's the other way around also. It's not. We're not looking. Even though it's the case that you can change your mind and decide ultimately to convict, that's not what we're looking to do. We're looking to find more acquittals. Tashma, I have another proof. What if you have one of the students who had an argument for acquittal and then that person died? Rowing also, this is an amazing statement. Rowing also ki'ilu chai v'yovid mukamo. So it seems like he's added to the court. In other words, we add him on to the panel of judges, um, and he dies. We continue to count him as one of the judges, even though he's dead and he can't change his mind anymore. He's not alive, right? We count the opinion he expressed for acquittal, even though he's died, that's a crazy idea. VMI, why is that? Nema ilu havakayim hadarbe. Why do you say that? Why do you say he might have changed his mind? Like, okay, so don't count him one way or the other. Why are you counting him for one side? He could have changed his mind if he were still alive. Whereas it's hashtam ilu hadarbe, but he didn't. He didn't change his mind. So we're going to count his argument in favor of acquittal. We're going to count it even though he's dead. Vaha, the
Why do we
Gemara.
say he's there? How can we even count him? He's not
I
there.
know it's crazy, right?
But didn't we have a Gemara earlier that said if you have two judges, one that even two judges say, well, let's say Machayev, and the other one says, I don't know. You don't have a court then, because even though he's sitting there, if he's not, but if he says I don't know, it's as if he's not there.
I don't know what to tell you. It's a crazy idea. The fact that it's even entertained seems extreme. Um, and in fact, it's not universally accepted. Hal shalchu mitam. They sent a word from Eretz Yisrael, L'divrei Rabbi Yossi Rabbi Chanina, Mutza miklal Rabbeinu. From Rabbi Yossi's statement, we see that he's like outside of Rav's opinion, right? That Rav's opinion was you can change your view from acquittal to conviction. so, um, so like the statement seems to be saying like, don't be ridiculous, right? You can change your mind. And the fact that this guy, before he died, expressed an opinion, we can't accept that. I mean, to me, like the better argument is, but he's dead. You can't have a dead person on the court. But it's why is that? Because, he's not subject to arguments, right? He can't, in other words, he can't change his mind once he's dead. So, all of the deliberation that's taking place is meaningless if it can't affect this person's opinion, right? Um,
Well, how long
so
can this go on? Weren't we did we say a few moments ago that they can discuss this the next day and the next day? Do we need a unanimous court? I mean, someone you work till we try to convince someone.
um, I guess
But I thought
I'm
we
not
don't want.
sure.
Isn't there a rule somewhere that unanimous court we never convict
Correct.
because
In capital cases, that's correct.
well we're talking about capital case now, aren't we?
Right. Right. So yeah, so
So
it doesn't mean you have to convince everybody, but it seems like the Gemara is saying you have to convince, somebody's got to change their opinion due to the deliberations. Otherwise maybe they weren't sufficiently exhaustive.
why did wait a minute? How many opinions? Let's say we'll take an example. Where's the court standing now? 20 versus whatever it is. It's a 23. So it's where 13 versus 10 at this point. Someone has to change his mind. We're waiting for somebody. Doesn't matter who. They keep deliberating until we get 14, then we get 11. Where does
So
this?
I'm not sure. I'm not sure if that's the case. Um, yeah, it, um,
You have to convince one person or two people, or as long as you convince one to switch from one view to the other, then we can accept it. I'm
mhm.
not sure I understand
No,
that.
okay. The Mishnah that we quoted is talking about where it's not deadlocked, but it's only a majority of one, and in the capital
Okay,
case, that's not sufficient.
right. They need
So
two.
so you have to go, keep arguing until either one person
Right.
changes his
Okay.
mind in favor of acquittal. So now it's a one vote margin in favor of acquittal, which is okay,
Right.
or it's a 3 vote margin in favor of conviction, which is also okay.
Okay. All right.
Where it says "ein mutza itmar," now we're going to rewrite that statement that Rabbi Yossi Rabbi Chanina is still within the bounds of Rav's statement. Okay. Tashma, we have another proof. Shnei shofrei dayanim amdin lifneim. You have two court recorders standing there. Echad min hayamin v'echad min hasmal. One to the right and one to the left. V'kosin divrei mezakim divrei mechayvin. They record the arguments. Bishlama divrei mechayvin. So I understand why they record the arguments in favor of conviction. L'machar chazu tamach. We know bo l'mevan halanas din. Because you want to have a record, so um, 1 second. Yeah, because maybe they'll find some other argument for conviction, and that requires another overnight wait until you can finish the case. But if they're recording, like, why do you need to record the arguments in favor? If you find an argument in favor, and everybody decides it's a good argument, and the majority decides it's a good argument, you can finish the case right there. So you don't need to record things so that you can review them the next day. Why would you have to record the arguments for acquittal? Isn't it because if they change their minds and say, oh, there's an argument for conviction, we won't listen to them. We don't listen to them changing their minds, right? So that's why. 1 second. The reason that you're recording all of the judges' reasoning and arguments is so that to make sure that they don't go back on an acquittal argument and change to a conviction argument. Wouldn't that be the reason to record it? Where it says, "Well, that's not why." You record it because you don't want to have two judges making the same argument but based on two different psukim. Okay, that wouldn't be valid. We'll expand on this a little bit. It's like Rabbi Asi asked, what if you have two judges that have the same reasoning but based on two different psukim in the Torah? Amarle, Rabbi Yochanan said, "Ein monin len ela echad." That's only, you can't count that as two votes. You can only count that as one vote because obviously one of them is wrong. In other words, the principle is that the Torah doesn't have redundancy, right? So if you have if you have an argument that the same rule comes from two different psukim, one of them must be wrong. So therefore, we're only going to count one of those votes. Are
you saying that both people are using that particular pasuk as a support to convict a person? So why is that? Why is that problematic? That both of them agree; those two judges agree with each other.
Right, but they're identifying, but there would necessarily be a redundancy. Like if you're advancing two psukim as the source for one idea or one law, then one of them has to be incorrect, because if you accept the principle that there's no redundancy in the Torah, you can't have the whole methodology of the Gemara is based on the idea that every letter in the Torah can be used for a particular purpose, and you never allow two different sources for the same rule, right? That's why we're always saying, well, if Rabbi X uses this word for one purpose, then what about Rabbi Y? What does he use it for? He's got to use it for something different.
Mm-hmm. All right.
Okay, where do we get this idea from? Rabbi, the pasuk says, "Achas dibra Elohim shaim zu shamati ki oz Elohim." God spoke one thing, and I heard two, because God has strength. That's the pasuk in Tehillim. Mikra echad yoseh l'kama tamim, ve'tam echad yoseh mikama mikros. You can have one verse that tells you two things, but you can't have two verses that tell you the same thing. Devera Rishmal Tana, or Rabbi Shmuel has a similar limud. Ukupati shifos tzela. This is from Mishlei, I think. No, from Yirmiyahu. The words of God are like a hammer, shattering a rock. Ma patizem is chalek l'kama nitzotzos. Just as one hammer can be broken. I think it really should makes more sense to say the rock. The rock can be, but the hammer is the tool. The hammer can break into many pieces. Af mikra echad yotze l'kama tamim. So one pasuk can be used to tell you many things, but not vice versa. Now, Hekadami, what? Give me an example. Tam echad mishnei mikros. What's an example of um, one rule coming from two different psukim that would not be valid? Amar Ravzvid, it's not, because it's not. Ravzvid says there's a Mishnah. Mizbeach mekadosh l'saroilai. The mizbeach can make kadosh something that is, that is basically valid, but for some reason, if you have something that a carbon that for some reason is disqualified, but it went up to the mizbeach anyway, then you should continue to offer it on the mizbeach. Mizbeach mekadosh esaroilai. The mizbeach makes kadosh something that was originally valid for it, but is no longer valid. But if it goes on the mizbeach, it's suddenly valid again. Rabbi Shomer, kol haroy ishim im yered. If it's something that's fit for the mizbeach fire, once it went up to the mizbeach, it shouldn't be taken down. Shenamar, because the pasuk says ha'ola al mokda. So we're taking two phrases that appear together. He ha'ola al mokda al mizbeach. That is the ola, the burnt offering on its on the fire on the mizbeach. So by taking these words in isolation, ha'ola al mokda, once it went up, ola shi really ishim. An ola that was originally supposed to be burned on the mizbeach, also loterid. Once it went up, you can't remove it. Afkol shoroi leishim imal leyered. That's the general rule. You can't remove it. So that's the pasuk that proves that. Rabbi Gamliel says a different pasuk. Anything that is fit for the mizbeach, if it goes up, once it goes up, the mizbeach shouldn't be taken down. He takes the whole pasuk. That is the burnt offering on the fire on the mizbeach. So, um, it's a little odd. They're using the same pasuk, but Rabbi Gamliel is using a more expanded quote from the pasuk. So what are they including in this? In what should not be removed from mizbeach psulin? We're talking about something that became disqualified. Marmai silami mokta, marmai silami mizbeach. Which is the key word that they're using? So Rabbi Yeshua is using the word mokta on the fire, and Rabbi Gamliel is using the word mimizbeach from the altar. So we're proposing that this is a case where you have two views, the same rule coming from two different psukim, right?
But same pasuk.
Well, but two different words in the pasuk, right? The Gemara is identified.
Right.
One uses the word mizbeach, one uses the word mokda. But the Gemara says, wait, it's not that they're saying, the same. They're arguing. Like one is saying it comes from word A, and the other word says no, it comes from word B. Diktani Seifa. And we have it's not like we're accepting both of them, right? They're advancing opposing arguments. We're not saying that they're both correct. Diktani Seifa, look at the end of the Mishnah. Ein ben divrei Rabbi Gamliel or divrei Yeshua el hadam v'hanasachim. The difference between them is the blood and the libations. She Rabbi Gamliel Omer lo yerdu. Rabbi Gamliel says you can't take them down because Rabbi Gamliel uses the word mizbeach, right? And these things, sorry, no. Yeah, it uses the word mizbeach. Um, these things do go on the mizbeach. The blood goes on the mizbeach, but it doesn't get burned. Doesn't go on the fire. Same with the nesachim, right? Rabbi Yeshua, Omer Yerdu. Rabbi Yeshua uses the word mokta, the fire. So these things don't go on the fire, so they're not included in the rule. So there is a difference between. They're not saying that there's two sources for this one thing. They're arguing over which is the source. Eleanor of Papa. So we need another example of where do we have two things, one thing coming from two sources. Kedetanya. How about this price? Rabbi Yossi Aglili Omer Mitoch Shanamar, since it says Kol Negev Mizbeach Yikdash, anything that touches the Mizbeach becomes kadosh, becomes sanctified. Shomayan Iben Roy Ben Shlo Roy. That sounds like anything, right? Whether it's something that would qualify as a carbon or something that wouldn't qualify as a carbon, right? If a rabbit touches the mizbeach, does that become kadosh? Talmud Lomar kavasim. So the Torah says kavasim, lambs, right? Ma kavasim ru'in. Just as lambs is an example of something that could be offered on the mizbeach. I've called roy. So the mizbeach is only mekadesh things that are roy. So a lamb goes up on the mizbeach, you don't take it down. But a rabbit, it's not relevant. Rabbi Kiva says, Ola, it says in Ola, Ma Ola Ruya of Kolroy. Um, Not from the word kavasim, but from the word Ola, something that could have been Ola that can be sanctified by the Mizbeach. So the Tarvayu Mai Kamatu, what are they excluding? Like I use the example of a rabbit. Well, what are they really talking about? Psuli, things that are possible things that are like a rabbit, right? That never is not relevant to the mizbeach. Marmai silami kvasim. One uses the word kvasim to exclude non-sacrificable things. Marmai silami ola. The other uses the word ola, right? So here is an example of two tanaim um, that are that have the same idea, but they use two different psukim or two different words in the pasuk to tell us. Ravana Barava, but Ravana said, "Ola sa'of pasula ikabenau." There is a difference. They are arguing about something. It's not that they have the same rule from two different words. It's that they derive a different lesson from, like they're arguing about which word to use because there's a difference. What's the difference? Ola sa'of pasula, a bird offering, a bird ola that is possible. So mandamai salami kvasim in avalos ha'oflo. So that would not be included by kvasim because of sheep, but not, like animals, but not birds. Mandamai salami ola. But if you use the word ola, so it's any kind of ola. Bird can also be an ola, so that would be included. Afilo olos name. So olos that is possible would still be sanctified by the mizbeach. So we're still looking for a case of one rule derived possibly from two different psukim. Elam Ravashi Kedatanya. We have another brisa. Dam yechashev lishu dam shafach. Um, um, what is this talking about again? Oh yeah, yeah. If you try to bring a carbon outside of the mikdash, so that's considered bloodshed. The Ramos is Azarek. That includes. So why does it say it twice? Dam yechashev leishahu dam shafach. The word dam twice includes somebody who does the zrika, the throwing of the blood. You can't do that outside of the base of mikdash either. Rabbi Shmuel says Rabbi Kiva Omer O zavach. Uh, um, um, He takes the same rule, but from a different word, ozavach. Avatarvayo my kamarbu. And what are they talking about? Zrika. They're talking about the throwing of the blood. Mar maisilami dami chashev, mar maisilami ozavach. They're each taking the same rule from a different place, from two different words in the pasuk. So maybe this is the source of the idea that you can't have two different the same rule derived from two different places. The Hammurabi Avo, but the Gemara says no. But Rabbi Avo says shachat v'zorak ikaben. There is a difference, right? It makes a difference which word you take it from. They're arguing. They're not agreeing on the rule because there's a difference. If you did both shchita and zrika, so according to Rabbi Shmuel, that's all part of the same forbidden act. According to Rabbi Akiva, it's two separate violations. But the Gemara says, wait a minute, Ha'itmar Allah, Amar Abaye, Afad Yibir Akiva Name, Abaye said that even according to Rabbi Akiva, Ein Chayav Belachas. No, there's no difference. According to Abaye, Rabbi Akiva agrees that it's only one violation. There, in that same passage, it's the Gemara says, the Torah says, you have to do B'makom Asher Yivchar Hashem in the temple. That's where you have to do your olos, and that's where you do it. Arvinu Rahman Olukulu Asiyos. By saying Visham Taseh again, that combines it combines all the violations within this category into a single technical violation. So in that case, we do have they according to Abaye, they agree that it's only one violation, but they still use two different words as the source of the rule. So this is an example of where you can have two different two rule. The same rule based on two different psukim, or two different words in the pasuk. Okay. Next thing in the Mishnah, Dinei Mamanos Danin Bayom. Monetary cases can be judged in the day and they can be concluded at night, but in the Nefashos, capital case has to be started during the day and has to be concluded during the day. It could be the next day or a future day, but you can't finish up a capital case at night. Minani milay. What's the source? Amar of Kia Bar Papa. The Amar Korah v'shaftu asa'am b'chales. It says that when Moshe is setting up the justice system, or when Yisro is suggesting how he should do it, it says they should judge the people at any time, right? So it includes nighttime. However, that's where the source that you can do Dine Mamanos at night, right? Yes, there's an exception for capital cases. We'll get to that, right? But the idea that you can actually that the justice system operates at night, and that's from this pasuk. So Gemara says Dinami. So okay, where do you get the idea that you have to start during the day? If this pasuk is telling you you can judge at night, you can start at night too. Why not just get to Rava? Rava tells us that. Rava asks the question. It says they can judge the people anytime. Another pasuk says on the day that talking about the laws of inheritance, it says bayom, and on the day that the inheritance takes place. So it says it has to be in the day. So how do you resolve that? Yom l'tchilastin, laila l'gmardin. Bayom, during the day, the requirement for the daytime is for the initiation of the case, for the starting of the case, and laila l'gmardin. But the case can drag on till night, and it's still b'choles. Like that's when you bring in the b'choles that the case can be judged day or night, but that's only if it's continuing from the daytime.
Where do we live? But we're talking about inheritance, right? Doesn't inheritance take effect the moment the person dies? So if he dies at night, isn't that when I mean, how we're trying to prove this from when inheritance takes place? But doesn't it really take effect the moment the person dies? If a person dies
yeah, I guess, but by saying biyom, it's saying like you can only adjudicate the case in the daytime. Like there's obviously there's some kind of talking about some kind of dispute in the inheritance. But maybe not. Maybe even if there's no dispute, the adjudication of it has to begin in the daytime. Mhm.
but
I mean, it's a little strange anyway, because like you're taking this one case of inheritance and you're applying it to all dine mamanos. Like, where do you get that from?
well, that's another question. But inheritance, I mean, the king becomes the king when the previous king dies or his father. Let's say it's a for kingship or mother, whatever. And if that's at 8 o'clock at night, it takes effect immediately, right? It's not, well, we're gonna wait until the
I
wait
guess.
for the coronation. I mean,
I don't know. Okay, let's say you're right. So what's the point?
so then you could then how can we make the argument that we're learning the judge the in this case the court case can only begin a day from inheritance, which could actually take place at night.
Because we have this pasuk that says bayom.
So then don't bring it from inheritance. I mean,
Well,
okay, so
you're
what's the base?
advancing.
Then what's the
What's
basis
your
to
proof?
say,
You need a pasuk, right?
okay, so what's even the basis to say inheritance begins in the daytime? When in fact,
Bayom hanchilah es.
yeah, but it takes place, it's effective immediately. It's
Then
effective
why
at
does the
night.
Torah say? Well, then why does he use the word bayom?
I don't
The Gemara
know.
is taking. Hmm?
Because when does the king become the new king? He doesn't become king till the next morning. Let's say they have war
I
gods.
don't know if there's a if there needs to be an affirmation by the court, then maybe that's the case. I don't know.
So the court, but
I don't know. I don't know if there needs to be any affirmation by the court. Where do you get? Why are you bringing the court into the case of a coronation of the king?
no, I'm talking about inheritance. So that's an example.
Oh,
Example, if we're learning this from inheritance, we want to say inheritance takes place only in the daytime. What if what if it takes place at night? I mean, inheritance takes place when it takes place.
so I don't know. Like we're inheritance appears to be talking about property. So your your attempt to apply it to a coronation may or may not be true. I don't know, or may or may not be valid.
Well, I'm talking, okay, you want to say, but inheritance doesn't have to refer to property. But in this case, he inherits the kingdom, right? So he did take the you have to have a ruler in place. For example, I'm using that as a form of inheritance. Okay. But I mean, you could say but let's say property. So he acquires the army, whatever it may be. A war takes place. Someone attacks them. Do you have there's no one to run let's say a family business, no one to run the business at nighttime because you have to wait till the next day? That's there's a
Yeah.
judgment. Someone encroaches on the land. So now we can't inherit, the next person cannot inherit the land because it doesn't. So then a crook can walk in the middle of the night and take the land because no one owns the land till the next morning. I mean, there are a lot of implications here.
Yeah, the estate. I don't know. I guess sure. Okay. There are. You could say that there are implications. I'm not going to argue with that. Um, but that's definitely the rule. You can find problems with it.
I did.
I don't know what to answer you other than that could be a problem, and I don't know how it would be dealt with, but not by speeding up the court proceedings in that way.
It just seems it seems rather strange to take this from inheritance. That's all. I mean, it's just.
Yeah, that I agree with you. I mean, in general, like why do you apply this word from inheritance to all monetary cases? Like that's my question. But yeah, your question's a good question. Anyway, Masnisin look Rabbi Meir, and we're going to say that the Mishnah is opposing Rabbi Meir. The Tanya, we have a brisa. Haya Rabbi Meir, what did Rabbi Meir say? Al PM Naga. Why does Torah say that by their word, meaning by the court, we adjudicate all arguments and all nega, every affliction, if you like. So sorry, it's not talking about the court, but it's talking about the Kohanim. They get to decide arguments and negaim, right? Like Saras. So Chimayin and Rivim negaim. What does one have to do with the other? Alamaki Shrivim negaim. It's making a connection between an argument, like um, a claim, and negaim and Saras. Ma Nagaim Bayam, just as Saras has to be examined during the day. D'chsiv Uviyom Heros Bai Basar Chai, like on the day that you see the Kohen sees a change, he can pronounce it healed. It has to be in the day. After Rivim Bayam. So also arguments or cases about money have to be during the day. Umanagaim shlo basumim, just as tzaras can't be identified by a blind coin, t'chsiv l'chom mare e'anei coin, because it has to be seen by the coin. For even shlo basumim, a blind person can also not be involved in a monetary case. Umakish Nagaim L'Rivim, and also you get rules about Nagaim from court cases. Ma'rivim Shlo B'Krovim, just as you can't have a judge who's a relative of one of the litigants. Af Nagaim Shlo B'Krovim, you can't have a relative who's a Kohen judge your nega. So wait, so should we also apply that to that you have to have at least three judges, so you have to have at least three kohanim for Nagaim of Vidinhu, and also it would make sense. Mamano bishlosha gufa l'kol like if you're going to insist on three judges for somebody's property, then for his personal status, for his own body, wouldn't you certainly want three judges? Talmud Lomer, so the Torah says no. V'huva el aharon kohen o el achad mivadav kohenim. It states specifically with Negaim that it can be just one person. Alamata shafilu kohen echad roas Negaim. Even one coin is enough for Negaim. So, okay. How Samya Dahava Bishavuse Rabbi Yochanan? There was a blind person who was in Rabbi Yochanan's neighborhood, Davadain Dina, and he was a judge. Rabbi Yochanan didn't protest. How could he have done so? But Rabbi Yochanan himself said, Halacha Kistam Mishnah. We rule like an anonymous Mishnah. It's not. Kasher Ladun, Kasher Lahide. The anybody who can be a judge can be a witness, right? V'yesh kasher lahayid, ve'en kasher ladud. You can be. There's people who can be good witnesses, but not judges. We're talking about someone who's blind in one eye. So blind in one eye, he can see, right? He can be a witness, but it's a technicality, if you will. He can't be a judge. So if Rabbi Yochanan wouldn't even allow a person who's blind in one eye to be a judge, how could he allow this guy who is totally blind to be a judge? So Rabbi Yochanan samach risashkach. Rabbi Yochanan had another Mishnah, like a contradictory stam Mishnah. Our Mishnah in the fourth parak here, Dine Mamos, Danin Bayam V'Garim B'Layla. Since the Mishnah rules that you can adjudicate monetary cases at night. At night is like when people are blind, right? In the dark, you can't see. So that would include, it's a little bit of a stretch, but that would include blind people that can judge. So Gemara says, "My only the high stomach." Okay, so fine. So you want to interpret our Mishnah as allowing cases in the dark, and that includes blind judges. But like, why pick this Mishnah over the other Mishnah, which says specifically a blind person can't be a judge, just like he can't be a Kohen, just like a blind Kohen can't do Negaim. So Gemara says, you might say I could answer Stama de Rabbi Madif. Maybe that Mishnah follows like the majority. Or you can answer Mishum Diktani Gabi Hilchasa Didina, because that was taught specifically about adjudicating cases. So this whole thing is a little unclear to me. Like, I mean, it seems to me that one Mishnah is very clear, and the other Mishnah is an inference that is a little, questionable. And that's why I would say, like, go with this Mishnah and not the other Mishnah. But I'm not quite sure what the Gemara is saying here. Like, why choose one Mishnah over the other? It's a little unclear to me.
Well, what's he, Gemara mean, Stama the Rabbim Adif? There are more judges are preferable? What's the point there?
No, that the Stam Mishnah that it follows the majority. That's the one we're gonna accept. So that Mishnah, the other Mishnah that says the that a blind person can't be a judge, just like a blind Kohen can't do Nagaim, that is following a minority view. And our Mishnah is following a majority view. I'm not sure how we know that. And but I guess if you have to choose between two opposing Stam Mishnah, then you have to, that's the way the Gemara is going to choose by saying, well, that was a minority view and this is a majority view. Or
The last one is Mishum the Katani la Gabe.
yeah, so that Mishnah is in Nida and it's kind of digressing from other rules. Whereas our Mishnah is in Sanhedrin, and it's dealing specifically with adjudicating cases with the rules of courts. So we're going to go with the Mishnah that is in the thick of it, right? That is talking about in the context of talking about courts. And we're going to accept that ruling over the Mishnah in Nida, which is a digression from other things.
So we hold that a blind person can be a judge. Is that correct? That's the bottom line.
Rabbi Yochanan holds that, yeah.
Is that the halacha?
I doubt it. That's a good question.
I mean, there are
I
today.
would be
There are
surprised.
people that are who are blind who are lawyers. There are lawyers. There are
Mhm.
lawyers who are blind.
Right.
Judges. Actually, I just read about a case in a judge who was blind. He became blind during his life, but he's a circuit court judge or a district court judge.
hmm Um, so it looks like the Rambam rules that a blind person can be a judge.
The governor of the state of New York was blind.
Oh, that's right. What was his name?
David Patterson.
Patterson. Right. Right. Okay, we'll stop here for today. It's getting late.
What about colorblind?
What?
What about colorblind?
What about colorblind? I don't know if that comes up. That's a good question.
Well, I knew a Rav once who said he couldn't judge on Ketamim, Benita, because he was colorblind.
Uh-huh.
He recused himself. He said, I can't.
hmm That makes sense. But it wasn't a general disqualification, right? It was just for that um, the particular area of law.
Right.
Yeah. Okay, I think we'll stop here for today. It's getting late. We didn't quite finish enough, but we'll try and speed up tomorrow. Have a shorter enough tomorrow. So hopefully we'll catch up.
All right.
Okay, have a good day, everybody.
Have a good day.